Sorry, my lord.
Just a moment. So we have quite a number of interested parties. So I will call on one from each side. First interested party, Councillor.
Thank you, my lord.
Yes.
Thank you for the industry that the court has shown in determining this dispute within the timelines that it has slowed down. My lord, we wish to submit to associate ourselves with the application by the petition. With regards to the request for a status quo order, this will enable the parties to ventilate the issues that the court has so referred to the petition that filed in Meru.
Yes.
And these interim orders will be able to avoid the disruption of the governance. We also wish to request for time copy of the proceedings as well as certified copies of the judgment. That is all I will say.
Councillor Kirimi.
Thank you, my lord. On behalf of the interested parties who opposed the petition, my lord, first and foremost, to thank you for the good judgment that you've delivered. And my lord, on behalf of all my colleagues who appeared before you, and as the senior most counsel perhaps who appeared before you, we are sincerely grateful for the opportunity to canvass the issues we did before you. My lord, so that I won't come again before you,
Yes.
we are also sincerely grateful to yourself for the professional courtesy that you extended to us.
Yes.
My lord, in a specific way, we are very grateful that you found in your heart to forgive us when we did not appear to be proper before you.
Yes.
And we thank you specifically for pushing yourself and ourselves to meet the strict timelines that you set to canvass this petition before you. My lord, turning to the application by Mr. Mutuma, we do oppose the same.
Yes.
First, you are now franked as official. Secondly, my lord, the weighty issues Mr. Mutuma is raising from the bar cannot be raised in an oral application. We kindly suggest that the petitioner finds it proper to file a formal application before you for urgent consideration and for a formal opportunity to all parties opposed here to file a response. Thirdly, Your Lordship, by making any decision that will amount to a stay of the negative orders you've just granted, with all due respect, Your Lordship, you will be sitting on an appeal of your own decision. And my Lord, this court will be making its orders appear inferior to orders of other courts. We urge Your Lordship not to be persuaded at all to grant any orders of status quo. My Lord, fourthly,
Yes.
there is grave injustice and prejudice that is going to be suffered by the people of Meru and the voters of whom I represent by an order of status quo or stay or an umpteenth time applied for conservative order. My Lord, that will be in breach of Article 10 and Article 1 of our Constitution, My Lord, fifthly, we are alive that the petitioner has a right to appeal against the decision. The superior courts may grant orders of stay if the properly says to that legal mandate. But your Lord, as far as you're concerned, you've done your work. We kindly ask you not to allow a stay of that decision even for a second. Because we have been waiting for this judgment. The court has rendered itself. It's upon all of us as parties to take up our other rights, and the constitutional frameworks and set standards should now take effect. We are established.
Thank you. So give me about 5 minutes to write. Yes.
They are more interested for the inside. I read for 5 minutes without you.
Because we have so many interested parties, if I extend to yourselves, for fairness, I'd have to extend to others. It's a straightforward issue. I think every council who walks into a court in this country and beyond has an application for stay in their mind, or how they will attack an application of stay if their side has won. So I'd request that you allow me to give my ruling, and we leave it at that. So this is my ruling on the oral application. The court has heard and considered the petitioner's application for status quo or stay or interim relief that would maintain the petitioner as the governor of Meru County and stop the consequent actions that the judgment of this court has allowed to take place from being implemented. Learned counsel for the petitioner has argued that the temporary relief in whatever form would allow the petitioner to adequately canvass the pending Meru High Court matter, which in the judgment of this court, a number of issues have been reserved for hearing and determination by that court. Further, Counsel Mutuma submitted that doing so would also allow the petitioner to effectively apply for and exercise her right to appeal to the court above. Counsel Mutuma argues that no party would suffer any prejudice, as in essence, the oral application, if granted, would merely maintain and extend the status quo that has obtained from 21st August 2024 for a few more weeks and months. Learned counsel underscored that, on the contrary, not allowing the oral application would result in significant changes in the governance of the county of Meru and would render the Meru High Court matter or any forthcoming appeal academic. In support, learned counsel for the first interested party, Counsel Lawi, on behalf of all the interested parties supporting the amended petition, echoed the submissions of petitioner's counsel and reinforced the need for a status quo order to allow for a seamless appeal process as well as a seamless hearing and determination of the other matter. Counsel Thanji, learned counsel for the respondent, opposed the oral application. She observed that the court is now functus officio and the petitioner has other avenues in a matter that is still pending, being the Meru High Court matter, or upon appeal. She concluded by noting that the judgment was clear that the Senate's actions and resolution were constitutional, and thus it would not be proper to suspend that action, and also this own court's judgment delivered earlier in today's session. Counsel Kirimi, learned counsel for the third interested party, and on behalf of all counsel for the interested parties opposed, added and argued that this court cannot stay a negative finding, and the granting of the oral application would amount to this court sitting on appeal of its own decision. Counsel Kirimi argued that stay or interim relief would greatly prejudice the people of Meru, one of which he represents in these proceedings, who have been eagerly awaiting the conclusion of this matter. The grant of the orders sought orally would also prolong the uncertainty in Meru County. He rested by arguing that in any case, it is a weighty application that should be in writing, with all parties being granted time to respond before a decision. I have considered the submissions by learned counsel and reflected on the matter in light of the unique circumstances of the case and the applicable judicial precedent, and I find that this court is not the appropriate forum for consideration of the grant of stay or the grounds adduced by learned counsel for the petitioner. Counsel explicitly referenced other fora that are, to my mind, better placed to consider and apply the injunctive relief sought on the basis of cases filed and pending before them or to be filed before them. I'm also satisfied that the Constitution and statute law provide for subsequent processes that would address any governance challenges that would arise from the operationalization of this judgment delivered a few moments ago. Lastly, I find that neither the petitioner nor the interested parties in support have identified any weighty issue that would or could be a potential error in my judgment just delivered that could form the basis of this court considering if there would be an arguable appeal or a just reason to stay this judgment in the interim. Overall, and noting that our constitutional order gives the petitioner ample time to seek injunctive relief in other fora, and noting that this has been a prolonged litigation in which the petitioner has enjoyed interim relief since 21st August 2024 with respect to a resolution of the Senate that has been found to be lawful by this court, I decline to grant the interim relief or stay sought orally. Certified copy of judgment and proceedings to be availed on priority. 14th March 2025. So I will work on the slight, yes, Ms. Lanch, sorry. No.
Sorry, thank you, my lord.
Yes.
We appreciate the industry and the time taken for briefing.
Council Mutuma?
Yes, sir. Thank you, Your Lordship, again for the industry. For your time is ruling. We abide by this.
Thank you, Council. I will, the only minor errors, sometimes when you read in your mind, you don't catch these errors. You can only catch them when you read out loud. They're very minor, so you will have this very shortly. Also, there will be a press release that will be communicated. I don't know why my court assistant has looked at me. My court assistant will get the press release, and it will be communicated through the appropriate judicial channels to the media. Before I rise, I'd like to sincerely thank Council on all sides for the manner in which you have argued your respective positions. I have been greatly impressed by the depth of your submissions. And even as a judge, I can safely say that I have learned things from reading your submissions and the manner in which you argued your respective cases. I look forward to seeing you all in future matters. Thank you. Have a good day.